Hello to anyone who has joined us. We are just waiting to get quorate with numbers, so we will start in a few moments.
I think your screen, Sadie, mine for some reason has cut off the numbers, so I'll leave it to you to view when we think we've got the majority of people listening.
Thank you to everyone who's joining us. We're just waiting to get a corporate of viewers before we kick off, so please bear with us.
We're only just back on 1400 at 2 o'clock now. I can see numbers coming up.
Oh, super.
So we'll just wait a few more moments, I think, to allow the people to buy their popcorn.
And Susan, where are you beaming out from today?
I'm beaming from sunny Sevenoaks in Kent. I feel like Joe Wicks. I should have jumped in.
Yes, you can't quite do the spot the difference, can you?
No, not really.
Maybe the next time.
Well, as we get better at this, I'm sure we'll have some more surprises we can launch on our unsuspecting clients.
You're on old hand at this, aren't you, Susan?
No, I've done some webinars. This is marvellous having you here, Sadie, because it's a very unreal experience when you're simply one person talking to an assembled, invisible audience. And that's the sort of ones I've done in the past. So this is going to be fun this afternoon because we can have some interaction.
Yes, and of course we've got the chance for question and answers, haven't we?
Yeah, so we've now got, I can see about 144 people signed up. So I think we'll it's going up still. I think we'll start just because we've got quite a bit to get through and we don't want to keep everyone here all afternoon. We want to do it in a way that is manageable and you can all get back to your much more important work afterwards. Thank you very much for joining us this afternoon, ladies and gentlemen, who I can't see, but a warm welcome from both Sadie and me. This is in fact the first in what is hoped to be a series of regular webinars on current issues in civil litigation. And we're very keen to give our views both from the point of view of acting for claimants and defendants. So it's as it were a neutral platform. The technology that we're using, obviously what we're going to be talking about this afternoon involves a lot of technology, but it's up to all of us now to have to become much more technologically able and not keep on asking our kids how to do things. So the presentation that we're giving you today, as you can see from the first slide, is on managing injury litigation in a pandemic. And who would have thought that's the sort of title that we will be using for any sort of lecture or talk, even perhaps 6 months ago. There are two important things that I just want to identify. This is not interactive, save as between me and Sadie, but please don't worry as we go through these slides because there are some that are quite wordy, but you will have access to them at the end of the talk. We're going to be putting them on the website. So don't panic if you can't get all the detail down. And the second important thing is you should be able to see, it's either at the bottom at the top of your screen, a little double bubble with Q&A. And that is the entry into the question and answer session. So when we come to the end, if you want to ask a question, I'm sorry we have to do it this way, you're going to have to press that and I think you then type in your question and we'll do our very best to answer as many questions as we can. So I'm now going to hand over to Sadie, who is the slide master and going to be conducting all that technical part this afternoon and take us through the slides as we go.
Thank you. And I think, Susan, is it right to say that people can type their questions as we go and we will look at them at the end?
Yes, I'm not going to confuse myself, but I think that it stores it. We're all working a bit blind, but yes, I think you can type and say.
Good. Well, thank you, Susan. We're starting our lecture today, or rather our interactive webinar with questions at the end, with what I hope is a slide by way of reassurance. Those of you who are familiar with his work will recognise the words of that great statesman, Donald J. Trump. And we see that, of course, the world, particularly the leader of the free world, was perhaps similar to some of the senior judiciary and those of us practicing in the field, caught a little short from his comments on the 22nd of January, at which time I think he was still describing this pandemic as the Chinese disease or some of those xenophobic ways, to his final recognition on the 17th of March that this is a real pandemic, a real problem. And of course, his attempts to bamboozle us all by suggesting that that was always as he had thought it to be. We shan't be suggesting here that we had always predicted that this was the way that the world was going to work, but I think it's right to say that COVID has definitely caught a few of us napping, particularly, as I say, and has come to demonstrate even the judges in the Supreme Court. So moving on, just to give a little timeline to reorientate ourselves into how quickly events have moved on. You might remember that back at the early part of March, there was a very limited scheme of recommended self-isolation that was confined largely to people who'd travelled in affected regions, who were demonstrating symptoms of fever and who were themselves within a vulnerable category. Elderly, already suffering from underlying health problems. But even then, I think in the very early weeks of March, it was largely business as usual from the perspective of the courts. Well, everything really changed, and it's with personal knowledge that I know this on the 12th of March, because at that time, my family were all affected by a relatively new, relatively continuous cough. So suddenly on the evening of Thursday, the 12th of March, the government advice extended to a new continuous cough. And so I found myself having to self-isolate back at home and obviously take what steps were necessary in order to deal with a busy court diary that I had then. Later, of course, that self-isolation period quite rightly was extended to 14 days, but in the commencement of it, it was simply a week. Now, matters moved forward then onto the 19th, and that was the first really significant judicial guidance on how we were perhaps to be approaching matters in the new age of social distancing and self-isolation. And there, the prophetic words from the guidance were indicating that perhaps even just one or more of the parties would be participating remotely. And of course, those words were quickly overtaken by circumstance, and by the 23rd of March, we were in lockdown. Now, that series of events through March did have serious ramifications in terms of trials which were listed at that time. And Susan, it was one of yours.
Yes, well, this is a really interesting slide, because we forget how quickly these issues have evolved. I had a trial that was in fact due to start on the 23rd of March. It was a contested liability case dealing with a road accident. There were 4 experts in different disciplines, 2 experts on each side. There were a large number of witnesses, 9 or 10 witnesses. And liability was fully disputed. So you can imagine the type of evidence that was going to be required with maps and screens and reconstruction evidence, as well as accident and emergency evidence on the issue of the reconstruction. And there was absolutely no problem. It was just after the self-isolating advice that had come through. The defendant herself was a vulnerable individual who was in her 70s. One of the experts was also, although very fit, in that vulnerable category due to age. And there was absolutely no problem. There was an agreement on both sides that we should adjourn the case. And we went ahead, and the court granted the adjournment really on the nod. And as you will see, that is now history. It is no longer the case. And so this is why I think the speed of this is very interesting, and we're still evolving.
Yes. And so really then turning to the current state of the market before we return to court matters, we have practice managers, latter day clerks, who are keeping a very close ear to the ground. They are trying to keep in touch with each of you and getting a sense from you all as to how you are faring in the new pandemic world. What we experience ourselves and hear from you is that we remain in a significant state of flux. There's clearly an anticipation that there will be in the short term an increase in policy claims, particularly those concerning coverage issue. And we'll speak a little later about a new newsletter which might be of interest to those of you who are looking at policy matters. Over the longer term, one of those claims conversations has produced information from an insurer which suggests that even in the month of March, when we were only in, one might say, complete lockdown, obviously with reasonable exceptions, by the 23rd, that motor claims were by then down by 50%, given the emphasis on social distancing and reduction of travel. So we, I think, must anticipate that there will be a downturn in volume motor, employer liability and public liability work in about 1 to 2 years. Obviously, if you're dealing with higher volume, lower value work, then that will hit you sooner. But the solicitors that we speak to by and large remain busy, optimistic that their work throughput will continue, at least in the short to medium term. And really the question is, how long will this complete lockdown last for? And what will the other side of it look like? There's perhaps a clue coming up for us that the senior judiciary are not seeing that as soon as lockdown is lifted, we will be going back to business as normal. And perhaps that we will be facing disruption to our social and working patterns, at least through to the autumn term, if not to the end of this year. And looking forward, of course, what we can reasonably anticipate as well, I think, is that there will be COVID-related litigation likely to be started, at least until such time as the court sends out a clear message as regards emergency conditions and their effect upon duty of care across a number of different fields. Leaving aside the first bullet point, which Susan, I know, has got very helpful insight on, and just looking further down the chain, of course, we can see that there are likely to be employer liability claims related to unnecessary COVID exposure, either through being required to travel on an unnecessary basis for work, perhaps too far into the lockdown, or for reasons which were not properly made out by the employer, perhaps with some duress against the employee in order to continue work, but also restrictions on the ability of employers to get hold of PPE. So claims which obviously won't be directly under the six-pack regulations, but by reference to negligence standards, are likely to increase. And obviously we've had the tragic news recently that as of last week, 20 bus drivers in London have lost their lives to COVID-related disease. So we're yet to understand exactly how causation will apply in those cases, but clearly they will be hard fought. And extending that employer liability issue outwards, I don't know about any of you sitting at home, but I know that my lower back is grumbling for sitting in an unergonomic chair in my study. Of course, I've got no one to blame but myself. But plainly in those circumstances where firms, employers were not equipped for home working and they've been asking employees to work at home, there will be some bodge jobs in terms of the working environment. And we question whether that, if reasonable complaint is made and nothing done to address it, is likely to see an increase in modest value EL claims in due course. But just turning back to those clinical negligence claims, one of the things that I thought was likely to be particularly interesting from a legal point of view, particularly in light of the Darnley case in the Supreme Court, which, if you remember, was the hospital, I always try to say hotel, but hospital receptionist who gave incorrect advice as to waiting times and who would be seen to the poor person who suffered tremendously as a result of deciding to take themselves out of the A&E service. I can see that there may be an extension of those principles into the 111 service, and that there may need to be recital in relation to the amendment of the standard of care or duty of care associated with emergency situations in order to protect that service from, frankly, the kind of claims that might be coming in.
I agree. Well, I think that this is a very interesting area. When we think about COVID-related litigation, obviously this is an unprecedented situation, and obviously we're talking about clinicians and nurses and indeed the entire staff of hospitals who are being very stretched. We're talking about people stepping into roles that they are not necessarily trained for. Doctors crossing through specialties in order to assist in this emergency. And I think that there will be a very different attitude to the standard of the duty of care, because you will have seen, I think, those of you who read the Times, there's an article today, the MDU is actually proposing to ask ministers to debate a question of immunity for clinicians and nurses in respect of COVID-related, and that's another whole topic, what COVID-related would amount to. But we can take a little bit of a steer from the states, because we know that some of these states now in the US are providing immunity from civil liabilities for injuries or death due to acts or omissions taken in good faith. So that another fertile field for lawyers. But I think that there will be some reflection of the fact that this is an emergency. I'm also concerned, however, about the comorbid host, the ones that we are hearing about, people who have had their cancer treatment suspended, people who have been unable to go through heart operations or transplant operations. It's a question really of how far the courts, and I suspect it will end up being the government, who I suspect will extend some part of the Coronavirus Act, will deal with this, how far they're prepared to go to protect the NHS in particular against allegations that their suffering and harm has been caused, not necessarily even directly by COVID. But then we have the other side of the coin, which you already talked about, Sadie, which is the care workers, the nurses, those who have died because of catching the coronavirus. Now, if they can establish that transmission has been due to some inadequacy on the part of their employer, I don't see that. I think that's a true bill. I think that's something that we will see litigation in respect of.
Yes, and those arguments on causation could be quite difficult. It throws up, for example, some of the relaxation concerning causation against individual failing talk visas that you see in the mesothelioma style claims. But certainly an interesting legal horizon ahead, I think, in relation
Absolutely.
to COVID-related claims, which may be coming.
And we'll have the whole panoply, won't we? Because there will be judicial review claims, or it will be a target, I suspect. A lot of
Yes. Yes, I think our public law team is very busy at the moment with the interface between all these rules and vulnerable people.
Yes.
Of course, there will be, as we can imagine, significant backlog to clear in the courts when the lockdown and social distancing restrictions ease in due course. Moving forward then to focus on our injury litigation topic, particularly in the field of medico-legal work. Of course, this is the central hinge in how we progress our claims. I included the note there of the quick volte-face, almost Trumpian in its style of Medco in relation to video examinations. Probably realised that was going to cause all of the lower value work to come crashing down around its ears. But of course, we still are finding it difficult in those cases where we don't have a full set of medical examinations under our belt to make real progress in areas of expertise which really demand a hands-on examination of the claimant. And we were thinking, Susan, weren't we, about whether there was any facility of getting around that by a video examination with almost the doctor having a sort of healing hand practitioner in a boiler suit doing the hands-on version of the exam.
It's very difficult, isn't it?
To see that one can establish the rapport that's necessary for the true medico-legal appointment. If that
I think well, you're going to explore this in a little later on, but I think there are certain areas of injury which lend themselves more readily to online or video examinations, and one can think of things such as a psychiatric issue, where it is a talking examination in any event with little physical. I think orthopedic injuries or spinal injuries or injuries where you require to actually see the patient and carry out neurological or other examinations, I can't see how you can do that. I just do.
No, indeed. Although saying that, in a case where I'm representing a claimant, the orthopaedic examination for the defendant proceeded by telephone. It can be said the orthopaedic evidence may be, but a small part of the picture, other things going on. But yeah, so Susan, you were referring, weren't you, to the conversation that I managed today with Dr. Valentine. For those of you who don't know him, he's a consultant in pain medicine and the director of the pain expert business, which he and I think his wife founded, which has now got a stable of around 15 to 20 pain experts, practitioners, both medics and nurses, I think. But my conversation with him yesterday was insightful because what he was sharing was that he has seen effectively the same steady stream of work that he would have anticipated receiving outside of a lockdown period, and that has included for him 4 new cases in the last month, which I think even he was pleasantly surprised by. The scheme of work that he is adopting is that he will perform video examinations on the assumption in consultation with his clients that there will in due course then be a follow-up very brief physical examination so that he can perform those hands-on part of his examination, or the reflex tests and the such like that he feels that he would need in order to acquit of a full report. And he's very flexible, and I think that we've found this again with experts, that they're willing to be as flexible as they can be, particularly in the face of some judges not being as quick to relax timetables in this period, as to whether or not he provides a provisional report for service or a provisional report which will then be finalised. And of course, if the provisional report is for service, then there'll be an addendum in due course. But 2 things, Susan, that he reflected to me that he thought were really positive out of this. The first was, as I mentioned here, the resolution of his long-standing bugbear of getting voluminous papers sent in box form rather than the provision of electronic files. And I think that's a very useful change in practice that we might see going forward for firms who haven't been adept at paperless working to date. But also that he, for his own practice, I think in keeping with many other medico-legal practitioners, to avoid losing preparation time, had adopted the habit of taking the face-to-face clinical examination, then reviewing the records and producing a report. And of course, that doesn't then give one the facility to look out for certain things in examination. So he saw that that was going to be an advantage if, over the longer term, whether or not there's an increasing cost, his clients would see the value of him continuing with an initial video examination and a follow-up hands-on.
Yeah, I can see the benefit of that. It also raises the issue, doesn't it, of the principle of recording and retaining the record of an examination. So previously it was the issue of just taping the examination, but now it will be a video record. So that shows another line of yes, and that may of course mean that the recent case of Mustard and the follow-up in which the examination facilities and the use of any recorded material was refused may end up becoming yesterday's newspaper, today's chip paper. Because if we do move to video examinations in this period where everything is digitally downloaded and available for review, of course, those issues will be by the by. So we can see, can't we, Susan, that there'll be real opportunities to change the landscape moving forward, and that move towards video examinations to be followed up or not with in-person examinations could reduce some of that rather tedious back and forth that solicitors sometimes experience over arguments around which venue a medico-legal expert will see a particular claimant or client in.
And of course, we've reflected the easy ability to record the examinations, which might, dare we say, in some instances improve the quality of the actual examination, but also in others perhaps reduce the number of personal attacks which are being made in experts in those follow-up witness statements. Well, or at least if those statements are being made, then the trial judge can review the examination and see very quickly for themselves where the fault lies. So we are into a dawning new age, really, in our injury practice.
Can I just interject?
Yes.
Of course, one of the things that will have to be worked out is the confidentiality issue, because you can well see that individual patients will be very cautious about having a video of their examination in some method that could become less than secure, and you've got GDPR issues there as well. So
yes,
it's still bits to be worked on, but
yes,
bear in mind.
Yes. Moving back then to court work, we were discussing earlier. So I mentioned in the introduction that the pandemic is making not only those of us at the lower end of the law, but also the Supreme Court justices look as though they were scribing in a different century. And interestingly enough, as I was doing the research for this talk, I discovered that poor Lord Hodge presented the Dover House lecture on the 10th of March on technology and the law. Now, the compass of this lecture was quite broad and was looking particularly at law keeping up with the technological developments as we move towards a knowledge-based society and knowledge-based industry. But he also made comments, as you can see here, around cases and how they might be handled using remote platforms in due course. And he referred, of course, to the fact that the Supreme Court has been ahead of the curve in relation to live streaming and using it indeed for appeal hearings with the Privy Council. But those words which I've highlighted at the end, you know, perhaps in future we might all be contributing remotely to hearings by means of such technology. And little did he know that within 2 weeks, the New World Order would apply. And of course, we'll go back to the Judicial Office message from the Lord Chief Justice on the 19th of March, which indicated at the very beginning of all of this that we ought to be considering, certainly the judges of the Civil and Family Court, sensible precautions to be taken in this period and permitting one or other of the parties to attend remotely. I'm really going to skip through these slides on the basis that they're sort of factual in a way, factual background. But they set the scene for what followed in terms of the High Court decision, which we'll turn to in a moment, particularly what followed the following day on the 20th of March, the remote hearing protocol, which, whilst it was amended on the 26th, maintained at paragraph 1 this provision that the use of remote hearings should be, was necessitated by the pandemic wherever possible. And that the protocol applied to all kinds of hearings, including trials, to be applied flexibly. So we kicked off quickly and rather unexpectedly with the 3-day Court of Protection trial before Mr. Justice Mostyn. And he knew well about that in chambers because one of our stablemates, Peter Mant, was one of the representatives in the case. And I don't think it was Peter, might have been one of the others, who then wrote to rather large audience about how successful the 3-day proceeding had been. That was an unexpected remote hearing because the advocate concerned had had to self-isolate on the eve of the trial, and it was better that it should go ahead in the circumstances. But of course, over the following weekend, an intermediary who was supporting the daughter, I think, of the individual around which the case was concerned, wrote in a rather chilling fashion about how difficult the experience had been for the daughter of the elderly gentleman, and how removed she felt from the whole process and unsupported by it. And that was even in the context of her sitting in a room with her representative and intermediary. So we reflect, of course, how less supported she would now be in circumstances where those people would not even be present. But continued it did. There was then a High Court commercial trial before Mr. Justice Tier, which went ahead. And then we came to a case which has been widely reported in the matter of 1 Blackfriars, which was a decision of John Kimball QC, sitting as a Deputy High Court Judge. This is a high value, high stakes piece of litigation that's going in for a 5-week trial in June. There are a plethora of witnesses, as you can see, and the joint liquidators who are the claimants applied at the pre-trial review for an adjournment of the trial in response to the COVID-19 restrictions. Effectively, they were saying twofold. One is that the restrictions would prevent them from adequately preparing for the trial, and two, that the trial would not be fair and efficacious in circumstances where it's conducted remotely, and in such circumstances where the technology was not stable or properly tested. Indeed, that application was quickly, it seemed anyway from the report, dismissed by John Kimball QC, specifically by reference to the regulations which had then been published. And he noted that the 2 exemptions to the regulations and the restrictions on movement, which specifically allowed a person to fulfill a legal obligation or participate in legal proceedings, sent a very clear message, he thought, from the legislature that it expected the courts to continue to function so far as they were able safely to do by the use of increased technology to facilitate remote trials. So there it seemed that we had a sort of overall safety message. So the primary aim was, can you go ahead? Is it safe to do so? And if that safety could be enabled through the use of remote trials, then so be it. And of course that echoed the contents of the guidance published on the 20th of March. Now, you'll see if I go back that that decision was promulgated on the 6th of April. But 3 days later, then we got the message to circuit judges and district judges, which was published on the 9th of April. And this is, it's important to note, crosses the jurisdictions that we're concerned with. It comes from the Lord Chief Justice, Master of the Rolls, as well as the President of the Family Division. As far as I know, and I could be made a fool of because something could have been published this morning, I did check, but it could have come out. This is the prevailing guidance, and I've given you the hyperlink there, which will be available on the slides on our website in due course. There, learning from the past 3 weeks or so in which true social distancing had affected the work of the court, the senior judges are telling us that business cannot be as usual. It cannot be until this emergency subsides. It reflected the feedback that judges were giving to senior judges, that these remote hearings are much more fatiguing, telephone more than video is also our shared experience. And also noting that in some areas, the management of the court were anticipating that judges would maintain their lists at the same frequency and number of cases coming through the door, of course, remotely on this occasion. And the need was felt to emphasise that that shouldn't be the case, that judges should not feel under pressure to list a certain number of hearings each day. Indeed, anecdotally, our view is that some of the have taken that a little bit more liberally than we might like them to do, but anyway, there we are. But we were told at that time that 40% of all hearings have continued, and later statistics published on the 11th suggested that up to 3,000 hearings were still going ahead a day. So really the emphasis that we place on this guidance is as regards what the senior judges were saying in relation to remote final hearings, which seemed to be in contrast to the approach that was being taken in the 1 Blackfriars case. So there, the emphasis was that there was no change to the conventional understanding that it'd be very unlikely that remote final hearings would be appropriate for many cases. But of course, the need to get on with dealing with any case needed to be balanced against the risk and effect of any delay. And that was perceived as particularly arch in the family context. And the emphasis there was on the restrictions, meaning that it was likely really that interlocutory matters, case management, or hearings that could be conducted by submissions only, appeals, cases with very little oral evidence, should be those that are taken remotely. But of course, the decision remains in the hands of the individual judge on a case-by-case basis as to whether a hearing will be conducted remotely or not. Susan, of course, has the example of a judge who was happy to agree the adjournment on the basis that the parties agreed. But that is not necessarily going to be the end of the matter, as the guidance sets out parameters for the decisions to be made on remote hearings and emphasises that the opposition to a remote hearing is a powerful factor, but conversely, an agreement is not necessarily a green light. And so we might see parties who consider themselves up, ready and able to run a trial on a remote basis, with the judges turning around and disagreeing. And of course, the difficulty that we have at the moment is getting these things before the court quickly enough that those decisions can be made without additional legal costs being wasted in terms of expert cancellation fees and the such like. So really, DI included for completeness as regards to the parameters, but it's worth noting that one other piece of feedback that the judges were getting from their brethren at the coalface was that a lot of litigants were finding it difficult to maintain the formality of court proceedings whilst on a remote platform, and judges, of course, as we've seen widely reported, were finding that they were being shouted at by parties to court proceedings who didn't have the benefit of a barrister who could spread out their gown and stand in front of them and try and mask them from the judge's eye. But anyway, I commend that guidance to you as very helpful, and we can see it in action from the president of the family division in the case of 3P, the decision of which was handed down on the 16th of April. So it is on its facts because it is a family case concerning care proceedings, but it is worth noting that these were allegations of the highest severity against a mother, but in circumstances where that short-term interim care placement that her child had been placed in was most definitely short-term and not certain to continue until such time as the trial could proceed in person. In fact, the parties with the previous guidance in their ears had worked on the basis that the trial had to be facilitated remotely. And at a PTR on the 3rd of April, the mother's representatives had primarily made an application to adjourn on the basis of her ill health. When that was refused, the planning was for mum to give evidence alone at home via video link. And of course, the technology being uncertain in those circumstances and her being entirely unsupported in that process by any kind of intermediary or lawyer who could interpret what was happening for her. But it's important to note that that was a fact-finding trial as well as fixing a final care plan. So Andrew McFarlane, in fact, I think, had been keeping an eye on matters within his division which were to be listed remotely, and he, I think, called the case back in, by which time the claimants, the mother's representatives rather, were advocating for an adjournment. And this was particularly well timed, Susan, wasn't it? Because you and I, in preparation for this talk, had been reflecting on the difficulties that a judge would have in a heavy fact case, or in one of those cases where it really is about sort of smelling the way the witness gives the evidence and getting a sense of their body language. That you particularly perceive that would be difficult to emulate in a remote environment. Of course, here, the judge spoke to that very factor by saying that it's a crucial element in the judge's analysis for the judge to be able to experience the behaviour of the parent, and that, I think that could be substituted for witness, who is the focus of the allegations, not only when they're in the witness box, but also when they're generally in the court and reacting or not reacting to the events that unfold around. But that really chimed with you, didn't it, Susan?
Absolutely, and as we discussed, I mean, in the commercial world, obviously remote hearings and technology have been going on because you have witnesses in various jurisdictions, but they tend to be, dare I say it, slightly drier cases that are very document heavy. And the world that I'm talking about here is those cases where your case depends upon cross-examination of an expert to show that he is not reliable or objective, cross-examination of a witness in situations sometimes where you haven't got hard objective data to be able to throw at the witness. You've just got to use your skill to be able to demonstrate that the witness is not credible. Now, I find it almost impossible to see how proper justice can be done by that type of a trial going ahead with a video link or remotely. And this is encapsulating the very points. And how interesting to find a judge admitting what we know, that it's not just when they're giving evidence, it's watching how this individual reacts to the other evidence, looking down on high. And we all know those clients, that dreaded clients who sort of make some comment and you turn to your solicitor and say, please get that client to trial.
Yes.
I mean, that's lost, isn't it?
Yes, that's right. So, I mean, we're reflecting here that, as ever, there's authority which you can rely upon and place different emphasis on to argue either way. But the most recent guidance is to steer away from trials being pushed on remote platforms at full speed. Again, as ever in this world, we've got such inconsistency of decision making. For example, I looked at the Central London court list today. All the circuit judges are concerned with appeals or handing down of judgments, such like that. But 2 of the district judges are concerned with trials, one of which is a 3-day multi-track. The other is a 1-day fast track. And you've heard, haven't you, Susan, of...
yes, I've actually spoken. So this is direct from the horse, if I can say that about counsel, the horse's mouth. Here is a woeful story. So the case concerns an employer's liability action. It's an accident at work. The claimant is a housekeeper, and she's injured when she's hit on the head by a very heavy curtain pole. And she has both psychiatric stroke, psychological and physical injuries. Now, liability has been admitted. So you'd think at first blush, all right, then if we're just going to a quantum trial, that might be more suitable for remote trial by video link. But as so often in the case, she has a previous psychiatric history. So there is question marks about the extent to which her current symptomatology is due to the accident or not. The claim, I don't think is it's in the hundreds of thousands rather than the millions, but it's a substantial claim. And the application, the claimant specifically did not want this to be a remote trial. I mean, she is being hounded by defendants who are not providing surveillance evidence, but they are suggesting that via her Facebook posts and her various elements of social media, she's carrying out a business and is able to operate perfectly successfully, and so on and so forth. So there's clear issues regarding her credibility. They're not actually raising it to the level of fundamental dishonesty, but as we all know, that the defendants are running it very hard and saying she's more capable than she is. And when she gives explanations, they're saying that they're not good enough. So very, very close to, and indeed one of the experts has used the word malingering. So you're right there in a very important case. Now, despite the representation by claimant's counsel, who was the counsel I spoke to, Central London County Court is insisting that it goes ahead via remote video links. They're using Skype for Business, and the judge who said that it should go ahead is not the trial judge. The trial judge is a very sensible judge. His Honour Judge Simon Monty, who I'm sure some of you have come across in the past as a really very effective mediator. So a very balanced judge. And they had a dummy run. I can't remember whether it was yesterday or the day before. And really, it sounds like a script from sort of Morecambe and Wise. So there were meant to be 11 people on the Skype for Business technology. Only, I think, 7 people were able to get onto the line. There was some that had a voice and no video, some that had video and no voice. And there were 2 counsels, 2 solicitors, 2 experts, and a whole host of lay witnesses. And it was effectively a disaster, a complete. Oh. So there was meant to be a second go, and we haven't yet heard, but they were going to have another go at 1 o'clock today to see if they could improve, and then decide where to go from there. So not just teething problems, not just technology, but real functioning disability. But I then said to the council, I said, well what about public access? What about the public being able to watch this trial? And he said, no, there's no provision for that. So where does that take us in open justice? I mean, I just find it extraordinary.
Yes, and one wonders whether or not that guidance is really filtering through, or whether the discretion that's being left to individual judges is being taken at its fullest extent. I mean, what we know is that the Northern Circuit are getting on with stage 3 CCMCs. We understand that they wish to do a trial of fast-track cases remotely, the DCJ out there. But for example, we hear from Midlands, particularly Birmingham, which is such a high profile, high volume court centre, that all trials have been adjourned until the end of May there. You shout up if you've got a different experience from that, but that would include the stage 3 hearings and approval hearings, which are in the band 2 of the civil listing priorities, according to central documents. So we really are in difficulties in terms of advising our clients on what is likely to be the outcome from an application. I suppose the best words are to try and achieve consensus views, and also perhaps, of course, to think of other options. Now,
I just want to lay the marker down here that I do feel that actually, in the interest of our clients, be they claimants or defendants, in these types of cases, obviously there are cases that lend themselves better, as you've outlined, Sadie, appeal cases, CCMCs, applications, all of those are perfectly capable of being conducted remotely. But these types of trials, I find it repugnant to the principles of open justice and fairness and balance for the clients on both sides, that we should have them going ahead remotely. And I think we should stand to ensure that message gets across, because I think there's a feeling at the moment that the judges feel they're so confused about the message they're getting, they're feeling they almost have to order that the trial goes ahead remotely, because that's what they think they're meant to do.
Yes, well, I would hope that armed with the guidance from the Lord Chief Justice and the Master of the World particularly, the submissions will at least be padded out and made more attractive to judges who are inclined that way. But as you say, there's no difficulty really with appeals continuing, and we just flag here 2 significant appeals which are on their way. The first involves 2 members of chambers in the Henderson Dorset Healthcare University Foundation Trust. That's coming on to the Supreme Court on the 11th, 12th by remote platforms. That's the 11th, 12th of May, I should say. So it's clear that it's right that that should continue by remote platform. But the interesting one, which we're all hotly anticipating, adjourned now twice, once with argument, once without, is the Swift and Carter accommodation appeal. And I think that's interesting. I flagged it earlier in my introduction, that has been listed to be heard remotely on the 22nd of June. And I think that really flags the thinking of the senior judiciary that even if we come out of lockdown in May, we're still likely to be facing significant restrictions around our movement and disruption of our work life, that it's safer and more convenient at this stage for them to keep their work throughput going on a remote basis.
Well, it's had a sort of a rocky path, hasn't it? Because it was adjourned first of all for the additional evidence. Then I think I think it was put back again just at the beginning. Now, so I think this is a very sensible move to get it on remotely. We also know anecdotally, do we trust the media, that I think the Grenfell inquiry, they're seeking to return to it via video, but yes. I know that groups representing the claimants are hotly disputing that as a fair form of tribunal.
Yes, because they want the glare of the in-person cross-examination, don't they, on those key witnesses?
Yes.
We'll see where that goes. Watch this space. So we, on these slides, have collated some tips from the front line. These are from our personal experience, also the experience of people within chambers, but additionally from sources on Twitter and the such like, where people who've gone through some of the commercial hearings have been setting out some of their tips for success. We commend those to you, but I will flick through them on the basis that Really, of course, the alternative to sitting and waiting for whatever the court service may look like, skeletal as it was before it started, and even more likely on the uppers, on its uppers rather, as we get through this difficult period, is looking at ADR. Our experience in chambers is that virtual JSMs are working very well, of course, looking at a certain value of case. If you're not aware of it, can I commend to you the 39 Essex Chambers JSM protocol, which, Susan, you were part of the drafting team, weren't you?
Yes, so of course, it's perfect.
Yeah.
No, there will be teething
problems,
but no, I was only a part, and a very small part. There will be teething problems, but we're proud to have had that out there, and I think it's already been picked up by some other bodies to use as their template.
Yes, I think then it may have been put into a Sweet and Maxwell publication, I think. But I mean, the beauty of that, if you haven't seen it just yet, is that of course it is a document which sets out parameters by which the parties can choose to operate going into a JSM. So that really we can make sure that any JSMs listed are not being affected by late service of documentation, last minute instructions needed to be taken and such like. And we found that where they are operated to, then the process works quite smoothly. We just also wanted to remind everybody of course, the traditional mediation offering, which is perfectly well suited to this kind of environment, particularly given we're all now so adept at different remote platforms. And within Chambers, we've got some really high-ranking names, which in fact before this process I wasn't aware, for example, that Sir David Foskett was mediating in civil litigation claims, but of course he is. A returning member of the High Court bench who retired a few years ago, and Sir Wynne Williams, similarly a former High Court judge who is now president of the Welsh Tribunals and continues to sit as an appeal judge in Jersey and Guernsey. And of course, Peter Hurst, who I'm sure you all know, who for over a decade was the senior cost judge of England and Wales, so, but also was a recorder, so very well placed to assist with mediation. But we wanted also to be able to flag to you these two very exciting new ADR schemes that we've got getting up to running in Chambers. The first is a fixed fee arbitration and advisory adjudication schemes. These are primarily targeted in the first instance at the lower value work, reflecting decisions like those of the DCJ in Manchester that no small claims are likely to be heard on his circuit until September at the earliest, but also reflecting on the fact that probably there are quite a few claimant solicitors firms and defendant insurers out there who don't want these kind of low value cases hanging around on their books until then. So we have got a working draft in progress for two schemes, one of which is binding, one of which is not, your choice. The fees are clearly set out, and there will be a smorgasbord of panel barristers from 5 years call up to potentially silk, who you, in conjunction with your opposing party, will be able to select as an arbitrator or adjudicator in order to try and give some resolution to those claims and keep that throughput of work going. The scheme overall is being mentored by some of the top international arbitrators that we have in Chambers. So people like Edwin Glasgow QC, Marianne Smith QC, and again, Peter Hurst, along with David Foskett and Will Williams, giving out their time as mentors, for which we're very grateful. But on the other side, of course, if your firm is concerned about cash flow and needs to progress some costs resolution on your bills, then our cost team, headed up by Peter Hurst, have already launched a costs ADR service offering provisional and detailed assessments by qualified costs mediators. The first scheme, the arbitration adjudication scheme, is watch this space. We hope to have it launched by next week. The cost scheme is already up and running. You will have the hyperlink there on the PowerPoint when it goes on the website. And finally, well, what can we do to help? Well, we're open for business as usual, even if the courts are not. As I mentioned earlier, there's an Insurance Insights newsletter, which Neil Block, Jonathan Bellamy and Edmund Townsend have put together to help you with seeing where the market on policy coverage and insurance claims may go. But also we've got this fantastic new service called Quarantine Queries. That is our attempt to help you replicate that system in an open plan office or otherwise, where you can go to the water cooler and mull over a particularly devilish problem that you have on one of your cases without having to trouble one of your colleagues who might be doing their Joe Wicks or the homeschooling challenge or anything of that sort. So if you have a query along those lines, it's an entirely free service. Feel free to email in the query to the CLG email address that goes only to the clerks if you're concerned about conflict, or to one of the clerks individually in our team, Ben, Tom, Hannah or Harry, and they will then refer the query to the right person on the team who will be able to book in a time with you Monday to Friday between 10 and 10:30, just to ventilate those issues and hopefully give some helpful advice to replicate that loss of your colleagues and their sounding board that they provide for you. So we hope that we have, by this talk, been able to provide you with some useful material going forward, particularly over the issues concerning adjournment of full trials. Those were all the things that we wanted to say. The URL that you've got there is as regards the Zoom suit. We skipped over the slide that we referred to that issue in, but you may have seen it going around in one of these light-hearted YouTube clips, and I have to say it made me chuckle all day yesterday. So if you want something to brighten your day, please do click on that link.
Well, I just want to thank Sadie and to thank all of you. I can still see that there's a large number of you that have hung on to the bitter end, which is commendable, especially on what is one of the lovely days outside. Thank you very much indeed for attending. I haven't got any questions up on my screen at the moment. I'm assuming that that's the case. If you do have a question, then please just send them through. And if you think of something afterwards, you know we're always very approachable. So yeah, the PowerPoint document is not going to be available by email. As far as I'm aware, there's a question saying, can you send the PowerPoint document by email to the participants? That is going to be available once you get it on the website. Now, I've got another question here saying that you cannot click on the hyperlinks.
Yes.
I think that's going to have to be a technical problem that we'll be aware of and we'll sort out. But I think once it's live, you will be able to. You can't click on them now because you were just having a shared screen.
That's right, yeah. So because we're using PowerPoint on a shared screen, then I'm afraid the hyperlinks don't work, even if you've got the wonderful technology of touchscreen. But as and when the slides are loaded, and I understand that's being done while we were speaking, onto the website, then you will be able to access all of those URLs by hyperlink on the presentation. So I understand from our marketing team that they will be in touch with each of you for feedback on the talk. We'd be very grateful if you get the chance to reply. And obviously, if they've got the facility to be able to send the URL linking to the PowerPoint at that stage with the feedback note, then they will. So
it's happening. It's happening very much. The wonder of modern science. It's actually going live on the web now. Thank you very much, all of you. I'm going to say goodbye now because I know you've got busy days and there's plenty more to do. But don't hesitate to get in touch with either Sadie or me if you do have any questions following this up.
Yes, Susan, if you've got a moment, actually, forgive me, because I don't know if you've realised, but we're starting to get some questions coming in.
Oh, I can only see receipts. If we get a primary, oh yes, I've got to scroll down.
Yes, there we are. So if you get a primary report, the questioner asks, we get a primary report via video with the understanding of addendum subsequently. Is the paying party likely to raise issues as regards the recoverability of the costs of the second report, such that it may be pointless to get a report via video in the first instance? Well,
that's because we're in a very unusual situation. I would think, I mean, obviously normal circumstances, that argument would stand. But don't you think, Sadie, here, if you're trying to progress the matter and if the court is indeed, if we're in a situation where the court's actually ordering that a trial goes ahead remotely, you've got to get as much evidence as you can, even if you don't get the second live examination.
Yes, and I suppose that you may do away with that issue, mightn't you, if at the first CCMC, if the case becomes issued and live, that you gain permission for both the original report and the addendum. So those arguments may well be taken against you on detailed assessment, but I would have thought that ensuring your timing was there, perhaps if you appraised the defendant that you might be considering video examinations and take an initial steer, or say if there's no complaint, then we'll assume that it's a benefit is to go ahead, that you can put your position that way. But the reality is that there are going to be some cases which do need to be progressed in these periods. Obviously, we haven't mentioned, which we should have done, Susan, the tweet which we both saw from APIL.
Yes, that's correct. Yeah.
The ability to file online.
Yeah.
And we're well aware, aren't we, in cases where you're pushing towards perhaps split trials and cat work, that you'd be looking at getting nothing more sometimes than a desktop into the parameters of injuries.
Yeah.
So we could see that there's correlation here with that kind of process, isn't there, in terms of those cases where progress does need to be made.
And now there's another question, or in fact an anecdote. I'm interested in this one about a central London judge who sounded very sympathetic because the solicitors couldn't get into the offices to prepare a trial bundle. Well, that's obviously a factor, and that's a feature that's going to arise in many cases now. And he also hadn't appreciated the impact of travelling on the advocates, because they might be living, as I am at the moment, with a vulnerable person.
Yes.
You happen to have got caught in lockdown with someone who is a vulnerable person. Now, I'm assuming from that, whether I get a response to it, that sympathy translated into an adjournment rather than an order for a remote hearing. But
yes,
if it didn't, let me just see.
Yes, I think we did get a response.
Yes,
yes, it was. Yes.
Yeah,
well, and I think that question does reflect something which is interesting about the way in which the judiciary do operate. And I think that it's a consequence of the inordinate pressure that judges are under to meet certain standards and to keep justice moving. But quite often, in a number of different regards, they look within the effect of their directions only as far as the courtroom. Hackneyed example of judges requiring submissions overnight from advocates who've got childcare responsibilities, so having to fit everything around that. But I think particularly in this era, there can be a little bit of short-sightedness from masters, and actually it takes an experienced litigator like the one who's asking the questions to be confident enough to remind the judge of what the practical consequence of their directions is, and hopefully that's the kind of advocacy that we can do on your behalf as well where necessary, if it becomes a contested issue. I can see that the final question, Susan, that we've had is as regards whether there are any reasonable or balanced mediators out there. I remind myself, Susan, that you're a mediator, aren't you? But also, obviously, we've commended 3 names to you within chambers already: Sir David Foskett, Sir Wynne Williams, and Peter Hurst. But there are other qualified mediators within chambers as well. I think Susan is one, Charlie Corey-Wright, and there is an ADR section on our website. So, of course, we can't say how they will, whether you will appreciate them as balanced or fair, but we imagine that they are in the way that they conduct themselves and equip themselves with their duties.
Thank you very much. I think we're now people are going off for their cups of tea, which is very well deserved. And I don't think there's any more questions, so we're going to close. Thank you very much, everyone, and goodbye.
Thank you.